Welcome to IP Goes Pop, your source for exploring the interface between intellectual property and pop culture. The IP Goes Pop podcast series is created and produced by Volpe Koenig, an intellectual property law firm based in Philadelphia, Pennsylvania. Visit us at vklaw.com. This program should not be considered legal advice. Please consult an attorney for your specific situation. And now your hosts, intellectual property attorneys, Michael Snyder and Joseph Gushu.
Greetings and cheers, listeners, and welcome to another season of IP Goes Pop, the podcast that explores the interface between patents, trademarks, copyrights, and popular culture, movies, music, songs, poems, haikus. We probably won't do haikus, but at any rate, this week on IP Goes Pop, we are talking about works entering the public domain, that is, formerly protected works of some kind, characters, cartoons, stories that are now free to all, free to use by all under certain circumstances. First, let me bring in our co-host, Joe Gushu, a fellow shareholder at Volpe Koenig. Joe, hello again, and welcome back to another season of IP Goes Pop.
Very excited for the new season, Mike. I'm happy to be back. Great to start off the new season with the new year and talking about Public Domain Day 2022.
We're going to get very public and very much in the domain during this episode.
I think we're going to answer a lot of questions that our listeners may have with this concept. So very excited to get into everything.
Joe, I think that's right. I think we are going to answer a lot of questions they may have. And we also may spur some conversation or raise some new questions that we do not answer. Let me also bring in our special guest, Mr. John O'Malley, a fellow shareholder from Volpe Koenig. John, hello and welcome back.
Hello, Mike and Joe. It's really good to be back. Thank you for inviting me.
And you may remember John from such episodes as The Tiger King. John was the inaugural guest, actually, on IP Goes Pop. And that will live with us in infamy. So, John, welcome back. This is exciting. It does not involve tigers. It does not involve attempted murder, but it is equally as exciting. And just another disclaimer here, this is not legal advice. This is for entertainment purposes only. And with that being said, I want to set the table with what were your favorite cartoon characters? So not superheroes, but just a non-super, I know I'm limiting this a lot, but non-superhero favorite cartoon characters that may or may not have appeared in, Saturday morning cartoons or movies.
Well, I guess I'll kick it off. My favorite was Bugs Bunny and the whole Warner Brothers cartoon family, but primarily Bugs Bunny was my favorite. I was never a big Mickey Mouse person, funny enough.
Okay, well, he seems to have still muddled through, even if you did not support his hijinks. But I will say that Bugs Bunny, also one of my favorites. All I recall is watching it when I was a kid, knowing that there was humor going above my head, way above my head, and still enjoying it anyway. And I think it made it that much better that it was written for adults. It was actually, to be played in movie theaters, either before or after movies. But I love the humor, and I think it set the groundwork for a lot of later humor that I enjoyed.
Oh, no doubt. Looney Tunes and Warner Brothers were a foundational part of my sense of humor. So watching countless hours of them as a child, that definitely sticks with you all growing up. And, a lot of, even later in life, a lot in common with people who watched and learned from Bugs Bunny, Daffy Duck, and the Roadrunner, and Wile E. Coyote.
And you would add those, I guess, to your. And again, everyone we're naming are characters that are pretty much up to no good most of the time.
Oh yeah, yeah. Those I learned a lot about the animal kingdom through them, and best practices when hunting. Also, and I guess in a gold rush, if I ever find myself in a country where there's going to be prospecting going on, I can fall back on all the lessons I learned from the Looney Tunes.
I thought as I got older that there was a company called Acme that you could order anything from, and it turns out it's actually Amazon. I don't know if you could order the hole in the ground, or the rocket sled. Oh, actually, you probably can order the rocket sled. I'm going to look it up and see if it's on my wish list on Amazon after this. So that is something that actually came to life. Now, we would be remiss. You can't talk about cartoon characters without, and John, you alluded to, without talking about some of the Disney characters. They are a part of not only childhood, they pervade almost all areas of popular culture. I will say that there was a Walt Disney World TV show that my family would gather around growing up, and it was always exciting to have a Jiminy Cricket or one of the Seven Dwarves, appear in our home TV and not have to go to the movies.
Yeah, I remember those shows as well, Mike. They really kind of rationed Mickey too. It was always a big deal when Mickey appeared on the screen.
Oh yeah.
And if you ever been to Disney World with kids, to try to find Mickey in the park it's probably easier now with apps and things like that, but that was almost impossible. It was you hit the gold mine when you found Mickey in the park.
Mickey or Minnie were, if you were about to board your plane or bus home and you had not seen them, that is a failure of a vacation.
It is. It is.
Yeah, to work, they meter them out. They know that they're the big stars. So,
but you have your Plutos, you have your Goofies,
Donald.
Donald Duck, kind of the inner, kind of the Rat Pack, if you will. I'm kind of mixing all kinds of pop culture metaphors, but maybe I guarantee if we looked hard enough, we would find something like the Mouse Pack and some kind of allusion to the Sinatra era, the way they have the main core characters.
Yeah. Goofy was kind of the Peter Lawler of the Rat Pack.
Peter Lawford.
Lawford, sorry, yeah.
I guess that makes Minnie the Shirley MacLaine. And I guess that makes Goofy that's Dean Martin. Boy, that could be a separate podcast.
The Mouse Pack.
So all of these characters, we talked many times on IP Goes Pop about copyright protection, and these characters and their stories, their movies, their drawings, illustrations are all protected by copyright. But shockingly, beginning this year, some of the big names in the cartoon world, which we'll get to, are what we're calling entering the public domain. So I want to talk about two things. First, just generally, how would you both describe what it means to be, before we get to copyright and copyright term and the expiration date, what does it mean to be in the public domain?
I'll start it off. I guess it means that it's, in my interpretation, it means that the story or the associated illustrations are available to anyone to reprint or use in new works, whether it be a new comic book or a new story of some kind, or something of that nature. Or you could simply, if it's a comic book or another kind of written work, you could just print it and try to sell it yourself.
Yeah. So basically, as part of having rights to different things, when something is in the public domain, it means that the owner of that particular character or work of art can no longer prevent the public from taking and using that particular piece of art or expression. So it's important that things do enter the public domain, because after so many years, some work may be forgotten. And when there's a question of whether it is in the public domain or not, the public is reluctant to republish something. So over the years, we've had a lot of different movies actually become lost to time because no one was able to reproduce the movie or save the film there and get it out to the public. So when something becomes in the public domain, it's almost rediscovered again and protected for the future because more people can be creating it.
So really, we're getting into a little bit about, I guess, policy surrounding, using art, making art useful. Because with copyrights, a lot of times we're talking about art rather than in patents. When we're talking about inventions or trademarks, we're talking about brands. Here, at least for this discussion, we're talking about, the art of the story, the art of the drawing, the art of the illustration. So, part of what you are trading off for protecting your IP rights, and we spoke about this on some other episodes, you're trading off let's call it a monopoly for a certain amount of time, a certain term, and you are getting protection. And after that, it enters the public domain, free to all. Other people can use it. Hopefully, they'll take it to the next level, as they say, or make it better. So, to get to the public domain, speaking about copyrights, and as just stories and illustrations and movies and cartoons are protected by copyright. Their works set forth in a tangible medium, film, digitally, papers, the old film cells of the original Disney movies. So, going to walk through the history of the Copyright Acts and how long things are protected for. So, John, in doing this, I'm definitely going to ask for your help, making sure I got it right, but also because I would say copyright is an easy type of protection to get. In fact, we were actually in a copyright litigation, and someone took an easel with a poster board and with magic markers drew a picture and signed it and they said to the court, I now have copyrights in that work. It is set on a tangible medium. It's on that piece of paper, and it's an original work by whoever the author was, and you have copyrights. That's how easy it is to obtain them. Now, to register them, there is a form that you send to the Copyright Office with a fee. But again, do you agree that it's easier to get than, let's say, a patent?
Yes, absolutely. I think it's much easier to get a copyright and get a registration for a copyright. Figuring out when a copyright expires is a little bit more complicated. And I would just say we haven't done the calculations ourselves on this, and we were just going by what's reported on various. Duke University has an excellent website that kind of tries to keep track of when well-known works go into the public domain. So we're basically relying on the work that Duke University has done, and we haven't made our own calculations of when these copyrights expire.
And by the way, those calculations can get very complicated because you have to, sometimes you have to look at whether the heirs have renewed it, when it was renewed, the years. But to provide some of the original timeline, there was a Copyright Act of 1909, and it had a certain duration of copyright, which is not really critical to what we're going to talk about today. Then came, by the way, every time I read this, I don't know why I laugh. The Copyright Act of 1976, which was effective January 1, 1978. They could have easily called it the Copyright Act of 1978, maybe at the last minute when they finally passed it, but I guess they made it effective 1978. So the Copyright Act of 1976, which was effective in 1978, essentially said that, look, any works existing by now that have been renewed in a certain window are going to get a certain term. And it is that window, the area of the 1920s, and I believe it's from 1925 forward now, where works are starting to come off of copyright, as they say, or the copyright term is expiring. Just for our listeners, the current copyright term, a safe rule of thumb, is the life of the author plus 70 years for a work that's done by an individual. For work made for hire, it's 95 years from publication or 120 years from creation, whichever expires first. Now, that is quite a long period of time. And much longer. Joe, for patents, what's, just to let remind our listeners what the patent term is?
Yeah, you're going to get 20 years for a patent. So this is substantially over that. And as Mike sort of laid out some of the different conditions, it gets really complicated depending on what year the first year of publication was for your work, knowing what statute to apply, and then applying the different time period that you have. So again, we're talking around 5 times longer for a copyright than you can get for a patent, at least.
Again, some things that seem simple at first, it can take a very long time to really unwind these threads of when a copyright was registered, when it expires, was it renewed? It can get really complicated. And also thrown into the mix, there were certain laws were passed extending the copyright. John, what about the copyright term extensions?
Yes, Mike, there has been, as you mentioned, a number of copyright extensions, and these were initiated for 2 reasons. One was it was very difficult, certain periods of time, to figure out when a copyright registration expired. It was actually more difficult than it is now. It's still a little bit difficult to do that. And the most famous extension was the 1999 Copyright Extension Act. Is also commonly known as the Sony Bono Act. And that increased the renewal term another 20 years from the 1976 Act. So that brought the key period another 20 years. So Mike mentioned works created in beginning in 1923, and brought it to those works would begin expiring in January 1, 2019.
So let me ask you this. It might be a little bit of a complicated question, but if you were a company that owned a $1 billion cartoon character, would you want to have a longer or shorter copyright term? I'll put that to the panel.
Call me crazy, but I would go for the longer term.
I will not call you crazy.
And that's part of the whole reason why this is so interesting, in that we're talking about these years, 95 years, 70 plus years. These are long periods of time that the original author for these is not going to be around. So it's either going to be their estate or perhaps a company that owns these rights who is very concerned about keeping them in force as long as possible.
So we've obviously set this up because there are some big name characters entering, or perhaps have entered by the time of this recording, the public domain, according to the information we have. Again, you would have to check with an attorney if you wanted to start creating stories or characters or images of anything. But based on the information in support of this podcast, let's start it off with the first character. You know him. You've seen him in his red shirt, perhaps with his hand stuck in a jar of honey. I'm talking about none other than Winnie the Pooh, not Winnie a Pooh, Winnie the Pooh. He is an actual Pooh. And I guess, John, tell us a little bit about the Winnie the Pooh and the character coming off of copyright.
Many people, like you mentioned, are familiar with Winnie the Pooh. The first characters appeared in books by A.A. Milne in 1926.
By the way, and John, before we go back, just kind of a interesting point to me is it's almost, for popularity of, let's say, a children's book or an illustration in a children's book, it's almost unbelievable to think that we are even discussing the same character from a 1926 book. That is the longevity of these characters and the potency that they still have. I think it's incredible that who dreams that in 100 years we want to make sure we have protection because this will be on so much merchandise.
Yeah, absolutely. They're great characters. And Mr. Milne, he created at that same time period, Winnie the Pooh, Piglet, Eeyore, Rabbit, and Christopher Robin. Also important, we can't forget that the illustrations were done by E.H. Shepard, and they have the same copyright. And those illustrations are important as well because they create the characters or the visualization of the characters that we're all pretty familiar with.
Mm-hmm. And it's from that original book that we're all talking about. That is what is entering the public domain this year.
Correct.
So when we talk about Winnie the Pooh, it's that the appearance and characterization of characters in that book. And then subsequent to that book, there was additional work done, perhaps new characters introduced, new renderings of those characters. And those are still protected under copyright. And that's how this gets a little complicated sometimes.
Yes, exactly. So, for example, Tigger first appeared in 1928. So the copyright on the character Tigger would, expire now in, math has never been my strong point, but 2025 if we go by what the reports say.
So let's go back to the distinction between there is, let's say, a physical book, a story with some actual illustrations, that the copyright will expire on that particular work, meaning that those characters will go into the public domain. But John, I guess, explain again what that means as far as later works or all of the Disney. It's not that you can't wake up tomorrow and start a studio for Winnie the Pooh creating a character that is the one that you see as you walk around Disney World.
No, you would have to go back to the original 1925 stories, and you could base your works, if you're doing something based on those stories, to the extent you follow those stories carefully or accurately, then you can theoretically, if the work's in public domain, use those stories. But you have to be careful that because there's been so many other Winnie the Pooh stories created by Mr. Milne or Disney over the years that you could theoretically infringe those later copyrights, even inadvertently, because the universe of Winnie the Pooh takes place in 100 Acre Woods. So theoretically, you could have the same ideas that subsequent authors who did Winnie the Pooh works for Disney, they came up. So it's a tricky area. You don't want to rush in and start creating Winnie the Pooh materials, and also you have to look carefully at the illustrations that were done to avoid infringing later works by Disney that are copyrighted, and that gets to be a tricky area as well as to what is kind of a new work or derivative work.
So, John, just to hear you explain it, I would say for someone with no background, if you have no background in IP, this just seems like a very tricky maze to work your way through, especially with a very large, any large company that's going to protect its work. Plus, isn't there also, you could run afoul of some trademark issues because trademarks can, in theory, last forever. And I am certain that there are multiple trademarks on the Disney version of the Winnie the Pooh characters and their names, for various merchandise and goods and services.
Absolutely. So, yeah, there are about 15 trademark registrations for, like you said, various types of goods, for plush toys, as you would expect, for recorded videos, recorded music, things like that. So you could certainly run afoul of those trademarks. But there are entrepreneurs out there who see opportunities. Winnie the Pooh, if it went into public domain January 1, 2022, January 6, 2022, someone filed a trademark application for zombie Winnie the Pooh. So somebody is probing and seeing what they can do. Those were actually the goods. It's kind of interesting. The goods for those are basically NFTs or non-fungible tokens and variations of that. So
interesting. All right. So another character coming off of or where the copyright is expiring is the original story for Bambi. It's called Bambi: A Life in the Woods, also from 1926. Felix Satan is the author. And again, we could potentially see new variations, new stories about the beloved character Bambi, in the woods with perhaps different or new friends rather than the friends that appeared, later in Disney movies. But now I think this is interesting for fans of Mickey Mouse in general. So now apparently, and again, this is from information that we have, entering the public domain in 2024, the Mickey Mouse original cartoons, Steamboat Willie, and the Gallopin' Gaucho. Two of those early
first appearance,
black and white. Yeah, the first. Now, Joe, I have to tell you, as soon as I hear Steamboat Willie, I have to think about The Simpsons, and of course, the first Itchy and Scratchy cartoon,
of course,
Steamboat Itchy, which ironically is not in the public domain for a very long time.
No, that'll be protected for quite a while yet. But yeah, Steamboat Willie. And everyone sees Steamboat Willie before some of the more recent Disney animated releases where it's played in the opening credits, crediting Disney Studios with the films. But yes, that was created in 1928. So per our math, Mickey Mouse is under copyright protection for a couple more years. And going back to just Disney's, I guess, interest in these copyrights, it goes back to an original character that Walt Disney created, which I think some of our listeners may know, which is Oswald the Lucky Rabbit, which was one of Walt's first animated characters, which he was unable to maintain the rights on. Universal Studios, actually, that was a work created by Walt Disney for Universal, and they took Oswald from him. So the rights of Mickey Mouse were forefront in Walt Disney and in his studios, and then subsequent empire he created around him.
So now, John, should I walk away from my current business and start my own production company for Mickey Mouse movies and cartoons tomorrow because of these two cartoons, the copyright's expiring?
Funny enough, there is someone on the internet, there's someone doing something on anything on the internet, but there's a countdown to when the Mickey Mouse copyright or the Steamboat Willie copyright will expire. And the operators of that website are threatening to that day launch their own materials, their own designs, and to basically start competing with Disney.
Even anyone who follows the Mickey Mouse character, who had kids or who was a kid, knows that that character has evolved, and there are so many versions and variations and so much content over the years that is still protected, let alone the trademarks that are still under protection, probably, at least for several more lifetimes. I just don't know how anyone could feasibly navigate it, even with a very small universe of original content, coming off of copyright.
Right. And then, theoretically, third parties can, download and distribute this material a lot easier now because of the internet and streaming services. But like you said, the Mickey Mouse character has evolved over the years from Steamboat Willie. And, if you have a kid and you give them a Steamboat Willie doll versus the current iteration of Mickey Mouse, I think the kid's going to feel...
What's this?
Yeah.
Did you get this at the dollar store? Yeah, this doesn't look like Mickey Mouse. What's this thing?
Exactly. So, I question whether there's ultimately, how much of a market there's going to be for this type of thing.
Another thing, if you look at the original content, and this might be true of some of the stories, kids today are very much attuned to a much quicker pace of stories, but also Steamboat Willie is the story of a steamboat captain who whistles. And that's about it. I think I just described most of the plot of Steamboat Willie. So if you love steamboats and you love whistling, have I got a cartoon for you? But if you like more action, I guess there is some action in the end of Steamboat Willie, but it's definitely a different pace and certainly an old-timey with the E on the end type of cartoon.
Yeah, it's a look back in time. One way to think about this when we say about entering the public domain, a company like Disney, like you can find Steamboat Willie around on the internet. It's not a problem. Disney likely has access to it on one of their many distribution channels. When we're talking about copyright and entering the public domain, think about it more. If there are works that you were unaware of being out there and no one's putting it out for the public to consume, it's good when things do enter the public domain because someone else can use it. While preparing for this episode, I saw that there was actually a film adaptation of the Great Gatsby made in 1926, which has now entered the public domain. It was shortly after the book was written, a movie was made. But sadly, through the years of time and film that it was actually recorded on, they cannot get the full film recreated at all. So there's just parts of it. So sort of lost to time. And you'll see now and then there are studios looking to transfer some of their older films digitally, being able to preserve them forever. And that was something that was lost. So sadly, that was a sort of casualty of some of the lengths of these time periods. But that again can enter the public domain and people could view that, whereas before they may not have been able to.
I want to bring up just a couple public domain myths, if you will. We're always talking about IP urban legends. One of our prior episodes, Joe and I did IP urban legends. Just because you can find a thing on the internet does not mean it's in the public domain. Just because some article on the internet says something is in the public domain does not mean you could copy it. And just because something does not, or a work doesn't have the copyright symbol, doesn't mean, someone's not claiming any rights to this. So again, it's really complicated. If you have questions, you really should get legal advice on it. I just wanted to also now, Joe, you know how we're always talking about movies and remakes and reboots and reimaginings and how everything old is new again. There are a number of books apparently that are entering the public domain, and I would not be shocked if we saw adaptations. Some of these are Ernest Hemingway's The Sun Also Rises, Dorothy Parker's Enough Rope, Langston Hughes' The Weary Blues, T.E. Lawrence's The Seven Pillars of Wisdom. There's a whole list of books. And, if you are a screenwriter and you know that Hollywood likes material based on known material, you might not have to obtain any particular rights if you were to make an adaptation of books that are no longer protected by copyright.
I think that's why we're starting to see some films based on Agatha Christie works get made for this exact reason. It's just,
Yep.
There's no problem with the copyright, so you can just adapt it and not have to worry about that. Going back a little bit further, think about all the movies that are inspired by Shakespeare's plays over time. I mean, there's a countless list of those. Those are all anything that enters the public domain that can inspire subsequent works just like that. So all these books that Mike's talking about, even the Winnie the Pooh character, the setting of that can be leveraged into new creative works. So that's another reason why, from the policy perspective, works should go in the public domain to spur additional innovation and creativity.
Yeah, I mean, I think a good example of that is Sherlock Holmes. Those works are, I believe, I'm pretty sure they're in the public domain because most of them were written in the late 1890s, early 1900s. And those are interesting because I listen to a lot of books on tape or Audible books. And there's an excellent, 60-hour narration of all the Sherlock Holmes books. And I had never read them before, but during the pandemic, I started listening to them when I was walking my dog. And it was fantastic. And I kind of what you were saying, Joe, you gain a new appreciation from some masters. I never appreciated how much influence Arthur Conan Doyle had on mysteries and whatnot through the years. And you see that in television. There's been a number of television programs the last 10 years that were basically Sherlock Holmes in current times, and they use
the BBC's Sherlock, just adapting it and moving it forward. Yeah,
exactly. And they just avoid the trademark issue by not putting Sherlock Holmes in the title or using it in any kind of marketing materials. So
yeah, and this is a reason why you also see some books in very cheap printed, at Walmart or any sort of home goods store you go into. You're like, why is this book so cheap? It's so cheap because it's no longer protected under copyright, so anyone can print a version of it. And it makes works a lot more accessible to the public that way.
Well, I will tell you, I was having a discussion with someone, and they thought that Romeo and Juliet is a complete knockoff of West Side Story minus the music and dancing. So
that's how it tends to get sometimes.
So I guess, let's go around. Final thoughts, Joe.
This is going to be a very interesting space to follow over the next 10 to 20 years, because in addition to all these animated characters that are beloved and well-known, you're going to see some superheroes enter the public domain because their time is going to be up with this. And it's going to be knowing how much a lot of these characters are being used in current times in movies and television shows, all sorts of media. It'll be interesting to watch how this plays out as we sort of untangle these rights and balance the creators' rights versus having some new innovation and creativity in the space. So I'm going to be closely following this area.
I agree. I think it's going to be really interesting. I expect a lot of litigation in the future as the copyright holders. I mean, it's estimated that Mickey Mouse is worth $3 to $6 billion to Disney. Same for Winnie the Pooh. So certainly Disney is going to protect its intellectual property pretty aggressively, and other multinationals will probably try and probe the extent of what intellectual property protections there are. And in the trademark area, it's not entirely clear where the limits of trademark protection are with respect to public domain. So I expect a lot of litigation in that area over the next 3 to 5 years.
Yeah. I my view is this. Part of me hopes that Disney swoops in and there is a law passed extending only their copyrights for the next 500 years,
Yeah.
just because I want to see the internet actually explode and eat itself with the online chat discussions about that. But other than that, I would just say, parents, be careful if you're purchasing one of these characters. Let's say a plush. If it's a Winnie the Pooh with a Y instead of an IE, you could have a very sad child when you bring that home. John, thank you so much again for joining us. Joe, as always, a pleasure. Listeners, thanks again for joining us at IP Goes Pop. We will see you out there in the public domain. Thank you.
The IP Goes Pop podcast series is created and produced by Volpe Koenig, an intellectual property law firm based in Philadelphia, Pennsylvania. Visit us at vklaw.com.